Hi, bonjour, ahlan wa sahlan. My name is Philip Bremer, and I'm the director of the Konrad Adenauer Stiftung Rule of Law Program, Middle East and North Africa. Welcome to a closer look. Today, we want to look at the new developments in Tunisia and speak about the new draft constitution. So a wonderful good morning to all three of you. It's a great pleasure to have you here with us. Professor Klibi, Professor for Constitutional Law and renowned constitutional expert at the Université de Carthage in Tunis. Thank you for being with us. Saïd Bernabia, you're the Regional Director for the Middle East and North Africa program of ICJ, the International Commission of Jurists with its headquarters in Geneva. Thank you so much as well. It's good to see both of you again. And then, of course, Dr. Malte Gaya, who is our Office Director in Tunis for the Konrad Adenauer Stiftung. As you know, we have country offices and we also have regional programs, me myself being the director of the Rule of Law program based in Beirut. We've come together to discuss the recent developments in Tunis and the new constitutional draft that was published on the 30th. All three of you have been closely following the developments in Tunis. You've commented and written about it, about the new constitution that President Kais Saied published in the official gazette just about 2 weeks ago on the 30th of June. Corrections were actually made a few days later on the 8th of July. Much more wording than content, but there are also quite a few differences in terms of content. Now, Tunisians have been called on to vote on this draft constitution on the 25th of July, so in 10 days' time, which is precisely 1 year after President Saied suspended parliament and dissolved the government. Some have called it a coup, others have been, a little bit more careful and have called it a power grab. And we just talked about this briefly before we started. A lot more has happened since then. The Supreme Judicial Council was dissolved and replaced. Parliament was explicitly dissolved. On top of the suspension, there have been several arrests. 57 judges were fired from their positions. He named the Venice Commission persona non grata. But, and I think this is also an important aspect, the population was also asked to answer an online questionnaire at the beginning of the year of some 30 questions meant to be the basis for the draft we see now. However, only around 7.5% of the population took part. So just with this brief introduction, I think we can see how much there is to talk about. We're going for 45 minutes. I'm very excited to get your strong sense, your opinions, your expertise on these developments, and very much looking forward to this. And let me start, Saïd, by asking you, when we met in Ramat a few weeks ago, we were both very much in anticipation of what is to come. And when the constitution was then published, the new draft, you tweeted, and I found this very much on point. You tweeted, as expected, it provides for an unbridled presidential system with an omnipotent president, a powerless parliament, and a toothless judiciary. So let me ask you, what, in your opinion, are the most surprising aspects of this new draft? And are you somewhat surprised at how blatant the difference is to the 2014 constitution, which was hailed worldwide as a constitutional milestone?
Sure. Thanks for the opportunity to comment on this process. When it comes to the content of the Constitution, I think the first major element that's not surprising, because I think it was consistent with what the president was saying, is the very notion of the separation of power, recognizing that the legislature, the judiciary, the executive are separate and equal branches of the state. And the president has been consistent in saying that the judiciary, for example, is not a power, is a function, or in criticizing the role of the parliament, or in criticizing the role of the cabinet. To have that written in the constitution itself, it was quite unique, I think, even by the standards of the region. As ICJ, we have covered other constitutional processes in Tunisia, of course, in 2012, 2014. We have covered other processes in Libya, in Egypt, but to find in a constitution that the legislature, the judiciary, and the executive are not equal and separate branches of the states, but are rather functions, I think it was reflective of the views of the president, that the only powers that matters is the power of the president. And the constitution itself reads more as a catalog of the powers of the president, what the president can do at the level of the judiciary, at the level of the legislative branch, and also the government. So the president can, of course, dissolve the parliament, can appoint the members of the cabinet and revoke them without any conditions, can appoint the judges. And I think it's important to highlight here that when it comes to the judiciary and the guarantees that were provided for in the 2014 constitution, they were all dismantled. In the constitution 2014, we had clear, strong guarantees for the composition, the competencies, the independence of the higher judicial council as an institution that guarantees the independence of the judiciary. All those guarantees were removed, and we have a situation or a constitution that's under which the president can appoint the judges, and that the views of the higher judicial council are not binding on this issue. The office of public prosecutor, this is also important, and under 2014 constitution, it was important to have that office independent, because the history of Tunisia shows that when you have prosecutors who are politicized or who are subject to the political influence, prosecutions are not based on the laws and the facts, but rather based on political considerations. And if you remember, in 25th of July last year, the president declared himself chief prosecutor. And Indeed. When we had situations in which president was not happy about the members of the parliament were meeting, he directed the Minister of Justice to direct the prosecutors to initiate criminal prosecutions. The issue of military court, and it's important also to highlight that the guarantees that were provided for in 2014 constitutions were important in terms of limiting the jurisdiction of military court to military offenses. And again, you look at the last year and how military courts have been used to target journalists, to target MPs, to target those who are suspected of criticizing the president. And you feel that the removal of those guarantees from the draft constitutions was by design and was meant to ensure that the judiciary as a whole, ordinary justice system, the office of prosecutor, military courts are there to serve a function. And that function, if we look at what happened in Tunisia over the past months, is basically how you can ensure that those who are criticizing or in position to criticize or being critical of the president are subject to prosecutions and politicized proceedings. And this just goes to the heart of the very idea of the independence of the judiciary and separation of power, and how you can ensure that the judiciary can act as a check on the president. And constitutional courts as well. I think it's important to highlight that under 2014 constitution, the constitutional courts has the competencies and the powers to review the president decisions and actions under the state of exception. That was removed. And also the constitutional court had the competencies and the power to try the president in cases of serious violations of the constitution. So the parliament impeached and the constitutional court that deal with the issue. And those guarantees also were removed. So basically gone, and basically what we have is a catalog of what the president can do. And in the same time, all checks that were provided for by the previous constitution on the president, on the executive in general, by the parliament and by the judiciary were removed. And as a result, we are in a situation in which the constitution just codifies one-man rule and dismantles all the checks on the executive branch.
I think a good example of this process you mentioned, and you mentioned the president calling himself the high prosecutor, is that I remember that when he did so, it was in fact the Supreme Judicial Council that then went to him and argued against this and criticized him for this. And it's the same Supreme Judicial Council that then a few months later in February, he dissolved. So you clearly have an example of what you just stated. Professor Klebi, I want to ask you as well, would you say that this missing separation of powers, as Saied just described it, would you say that is your biggest worry as well when you look at this constitution? Something I find very kind of noteful as well is that the head of the commission that drafted the constitution, a few days after it was published, publicly distanced himself from it because he said this draft has nothing to do with the constitutional draft that we gave to the president. And then we've seen the corrections a few days later, where you also stated that with these corrections, the draft is much worse than what we saw on the 30th. So I'd like to ask you if you could explain that. How with the corrections is it worse? And would you also agree that, or what is your biggest worry looking at the new constitutional draft?
So thank you very much. My biggest worst is what Mr. Ben Arbiya said about the separation of power. And second thing, my biggest worst is that in the beginning, when the draft has been first published, people looked only to one thing, which is the Article 5 of the draft. It is about the identity, if we can say that, of Tunisia. And it says that the state has the monopoly of managing religions, and his mission is to achieve the objectives of Sharia. So all people pointed to that, discussed about that, was worried about that. But this is not really the most important thing. The most important thing is, the most threatening thing is the institutional engineering in the draft. And you asked about if you were surprised by the draft. Yes, I personally was surprised, because it is a draft that is very near from the 1959 constitution. It is a model that institutes the president as the center of all this engineering. He has all powers, and he's not, absolutely not, accountable, as Mr. Ben Arbiya said now. And this is very threatening for the future for the citizens. And if we pay attention about all what the president did under a constitution which bound him and not give him too much power. So let's just imagine what he can do, he or anything else in the future, with all these power. So I think this is the most threatening thing, and the most thing we have to pay attention to. Now, what about the new draft, the second draft? First, it is I think it's important to say that it has been done not in compliance with the legal procedure. The decree law that organized the constituent process said that the draft must be published at least on 30 June. So a draft published on 8 July is not legal. The second point is that this second draft gives a feeling that the president is listening to the citizens, and that this second draft is a response to the concerns of the Tunisians. This has a consequence. It can lead many people to change their position about this draft. Those who decide to vote against, maybe they will vote the draft because they will say, so it's good, he's listening to us, he changed the things, the element that was worrying or threatening. And this is not true, because nothing important have been done in the field of the institutional engineering. The new draft didn't change anything in the powers of the president, didn't change anything about reviewing the president's acts, controlling the president's act, didn't do any or change anything in the statute of the judiciary. And all these elements have been noticed by people, and citizens expressed their worry about these things,
So the core elements stayed the same.
Absolutely. So I think the most worrying thing is the intention, even if I don't like very much to make to judge intentions, but I'm wondering why this second draft. Why? What is the aim of the second draft? And when I see some reactions around me, I understand that maybe the aim of this is to make people change their position about this draft, while nothing really changed. He introduced a mention of democracy, which was totally absent from the first draft. This is worrying. This is worrying. This makes everything wondering where we are going through.
So to clarify that, especially for example in regards to the rights and freedoms, something that was missing before, and he added now was to add a sentence saying so can be restricted in the frame of a democratic.
Exactly, a democratic. So he also added the proportionality in Article 55, but civil state that has been removed, comparing with the 2014 constitution, haven't been introduced in the new draft, while people called or asked or demanded that demanded that it will be added. It hasn't been added. So I think the most worrying thing is the way some people, let's say some people, reacted to this change. Many of them reacted positively, but finally, in fact, if we read the draft with attention, we understand that nothing, in fact, nothing changed in the most threatening elements. So that's it.
You mentioned the legality, and something that I also find interesting is that the entire process, the way this new constitution has been rolled up, also actually explicitly goes against the 2014 constitution, which in its articles, expects a participation of parliament, of the constitutional court, when a referendum or a new constitution is drafted, which currently, isn't possible anymore because we still don't have a constitutional court, and parliament has been dissolved. Saied, let me ask you about this process. Has this process, in your opinion, kind of reached the general expectations or requirements of a constitutional amendment, or indeed a new constitution? And let me add a second question. Something that I find worrying is the amount or the several aspects that are mentioned in this constitution but aren't actually thought through until the end. So there's a lot of articles where the president has sort of said this will then be regulated by law. So whoever is voting for this referendum doesn't actually know what they're voting about, because there is just the short sentence, you know, intention is the following, but it's quite simple, and the rest will later be regulated by law. So in fact, this draft constitution doesn't go into details at all. If we look, for example, at the legislative chambers, and he wants to install a second one, we don't know anything about how these chambers are supposed to work together. We don't know what the intent exactly is of the two. So there's a lot missing. So I went on for quite some while, but to recap very shortly, the process
and regulated by law.
Yes.
Yeah, so let's start with the process. I think for all its ills, and there aren't that many, you know, just to be honest, you know, the 2014 constitution, we have been critical. You can, our report on the 2014 constitution at the time said that it was a missed opportunity because there was a room to enhance more guarantees on rule of law issues, on human rights issues, on the civil character of the state. But even with our concerns at the time, we recognized that the 2014 constitution was the result of a legal, legitimate process, an inclusive process. It was the product of a constituent assembly that was elected by the Tunisian people through fair elections. And we were happy with the outcome because that outcome was the result of process that lasted for 2 years, that was inclusive, that was transparent, the people were allowed to participate. We as civil society organization participated. We worked with the members of the National Constituent Assembly, with the commissions. We provided input, technical support, advice. The members were allowed to have also discussions with other experts, just in terms of comparative perspective. The drafting itself, you know, just how to draft the article to ensure that it's reflective to all of views and inclusive, etc. So for all its shortcomings, and there aren't that many, you know, just to be honest about it, you know, because now people criticize the 2014 constitution as if it was some kind of constitution that is that's the reason why we have the political gridlock that we had in Tunisia over the past few years.
Let me quickly ask why. Is that the only reason the 2014 constitution is so heavily criticized? Because it is seen as the basis of the gridlock?
It's, I think, at least in terms of defining what's the political system. Is it parliamentarian? Is it presidential? Some people are saying now that the 2014 constitution provided for parliamentarian system, and this is why there was disagreements between the president and the prime minister and the parliament. It's not a parliamentarian system. No one can read, you know, the constitution of 2014 and say this is a parliamentarian system. And the president has powers, and the prime minister or the president of the cabinet has powers. But the intent of the people who drafted the constitution at the time was clear, that Tunisia has experienced an unrestricted presidential system for 55 years under Bourguiba and Ben Ali. And because of the unrestricted presidential system, we had all the abuses, all human rights violations, all the attacks against the rule of law, independence of the judiciary, etc. And this is why the drafter of the 2014 constitution wanted to put limits on the power of the president. And this is why they had this idea of dividing the executive powers between the president and between the president of the cabinet or the prime minister. And that division works exactly as it works in France if the president and the prime minister are from the same political parties. But if they are not, then you have a situation of coexistence, cohabitation, and you have to look at the best interest of the state and to try to find compromises. So when people failed to find compromises, they blamed it on the constitution. But at having an executive with two heads, prime minister and the president, that's exactly the situation in France that's influenced, even though constitutional law experts in Tunisia sometimes deny that it's been influenced by the French system. But I think for historical reasons, you had that influence there, including the article on states of exception. I remember the discussions at the time that we had with the Constituent Assembly. Why do you need a state of exception? Why it has to be there? You just had a revolution. Why there should be a provision on states of exception that gives the president almost unrestricted powers? And they said, well, this is something that was there in the French Constitution, and if you read the articles, it's almost the same article, the same provision, the same procedure. Anyway, I think for all its shortcomings, that constitution was the product of a legitimate Constituent Assembly. What we are seeing right now, what was submitted to the Tunisian people, is the product that is not consistent. I mean, the whole process was not consistent with the procedure on constitutional amendments that is provided for by the 2014 Constitution. In many countries, changing the Constitution outside of this framework, that's a crime in itself. And those who are taking part in the process are complicit in such a crime. So let's just be clear on what's happening here. What's happening is that the president gave himself the power to change the constitutional order without any legitimacy, without respect to the constitutional provisions provided for constitutional amendments, and with the support of law professors, of lawyers, etc., etc. But that process lacks any legitimacy, lacks any legal basis. And even if it was compliant with the procedures provided for by the 2000 Constitution and was legal and was legitimate, the way it was conducted, it was not inclusive, did not include political parties, the wide range of civil society. It was not transparent. Until today, we don't know who drafted that constitution. If the members of the committee themselves are going to the media to say that they are not responsible, or they are not the ones who drafted that, or that the draft does not reflect even 20 or 30% of their views, then the question, who drafted that? And if we don't know who drafted the constitution, that's in itself problematic. If we are in a situation in which the president himself or through his advisors is drafting a constitution, that runs against the very basic foundations and principles of the rule of law. Because if we give president the power to write constitutions for themselves and how they should run the country, what is left, for democracy, what is left for the rule of law? And I think also in terms of the time frame and the possibilities for people to contribute to that. We spoke about the 2014 Constitution. It was 2 years process that allowed for people to provide input, to have their views considered, discussed in public, through media hearings, even by the committees of the National Constituent Assembly, all of which is absent from this process. And because the process was opaque, non-transparent, lacking any legal basis, any legitimacy, we had a situation in which the drafting didn't match what we were told. And that's just a normal result if the process is not inclusive and deliberative. And we are just one person or some of his advisors writing a constitution. So we had 46 amendments. Many of them are just correcting typos and material errors. Some of them are significant. I think, with Professor Sabir was saying, I think one element was the election of the parliament, the direct election of the parliament, because that was also a source of worry, because it wasn't there in the first draft. At least now with the amendments, there is that possibility for people to directly elect their members of the parliament. And we are considered that to be an achievement, because you would think that's just the right of Tunisians to elect their members of the parliament, and that shouldn't be denied. And even with that, actually, it was denied in the first draft, and we didn't know how the members of the parliament are going to be elected. Which brings me to the second point about regulated by law.
Things missing. Yeah, and also quite a lot of things just generally missing.
Yeah, and I think it's missing because the process was not, you don't draft a constitution in 3 weeks. Whoever thinks, and I think, some people or law professor think, or at least President consider himself constitutional law professor, and that he knows it all, and that he had read, about constitutions. You don't draft constitution in 3 weeks. You don't draft even a law in 3 weeks, let alone a constitution that should regulate the functions of public powers, of the parliament, of the constitutional institutions, of right and freedoms, of the character, the democratic character of the state. So because of the time frame, you had all these errors. And sometimes I think it was by design. I think this idea of referring to the law to regulate these issues was by design. This was an agreement here between Belaid and between the presidents. So let's not have the most, let's have just the general principle in the constitution and then the details in the law. And that's, again, runs counter to the very basic principle of the rule of law and modern constitutional making processes, because the more guarantees you provide in the constitution, the most difficult for government and parliament to undermine them. So you would want better guarantees, more guarantees in the constitution itself. And you have one concrete example here or at least two. We have the Higher Judicial Council, for example. If you provide that the composition, the competencies, the guarantees related to the Higher Judicial Council are regulated in the constitution, then you are protecting that Higher Judicial Council from any abusive use of legislative process or executive process by the government or by the parliament. So the parliament's hands are limited. They cannot intervene to change the composition or the competencies of the Higher Judicial Council, and therefore the Higher Judicial Council is independent. And the same thing for the EZ, for the board, the Electoral Commission. And the 2014 Constitution provided for it to be elected.
Let me quickly interrupt you, because I think the sentence is very important to state that everything you just stated is not in the Constitution in regards to the Higher Judicial Council.
Exactly.
Just to make it very obvious.
It was in 2014.
Yes. It was in the.
It was in 2014 Constitution.
Yes, but it's not now. It's no more now in the draft. And just excuse me, just to go back to the election of the directly the member of the assembly directly elected. I think it's not an omission, because if we read the drafts prepared by the Belaid Commission, we will note that it provided that the members of the assembly are directly elected. So I don't think it is an omission. I think the president decided not to mention that in the draft, because he's thinking about his project of bottom-up system, democratic system, where the assembly is not directly elected, but it is composed of members that are chosen from regional and local assemblies. So I think this is also was very worrying, because the president, the fully power president, was facing a very weak legislative and a very weak judiciary. That is the project made by the president in the first and in the second draft.
Saied, sorry. Did you want to continue? Did I interrupt you?
No,
Professor Klebi?
No.
So Saied, I interrupted you. If you want to finish the second point, and then I'll try and bring Maritza into the conversation as well.
Sorry, Ms. Saied, I interrupted you.
So Saied, if you want to finish up the second example. So the first example was the Higher Judicial Council, and the second example.
The second example was the Electoral Board, and I think it's important here to highlight, under the 2014 Constitution, Electoral Commission, the members of the Electoral Commission were to be elected by the Parliament. And it was clear, in the Constitution that they are to be elected by the Parliament, that they must be independent, that they must be impartial, and you have certain criteria that were in the 2014 Constitution. Here you are just saying that they are going to be independent, that the members will be independent and impartial, but you don't make, and the Constitution does not make any reference to what are the criteria for such members to be appointed or elected, who is going to appoint them or is going to elect them, under what conditions, etc., etc. And therefore, you are just codifying a situation that exists already. in which the president appoints all the members of the Electoral Commission. And the Electoral Commission's independence and impartiality, or the impartiality of its member, is undermined because they are accountable to the president. You could see right now that the president will order the president of the EZ to come to visit him in the presidential palace, and he would go, while we are in a context of a referendum, and that the president is involved. So the guarantees for the institutional independence of the EZ and individual independence of its members that were provided for by the constitution were removed and were replaced by a process, or like by framework, that is consistent. Because when you were asking about whether any of these were surprising, well, it's not surprising because the president already put all these elements in the decrees that he issued over the past year.
So they're in place at the moment. I mean, it's basically what is happening in practice today.
It is. That's the reality of Tunisia right now. So that's
and something you mentioned previously, which I also find extremely important. So the new draft explicitly says that every judge is independent, but at the same time, the president, is responsible for the kind of recruitment and the acceptance. I'm missing the verb for the installment, so to say, of appointment.
Selection
selection of every single judge, which is something you don't read so often. Maite, let me bring you into the conversation, because something I would also find very interesting to hear your opinion on, but also a question in general to all three of you. What are you hearing on the ground? So with the partners you have, Professor Klibi at the University de Carthage, at the faculty, people on the street, the taxi driver. Maite, let me start with you. What reactions are you picking up? And what is your personal opinion on what will happen in 10 days' time on the 25th of July? How do you think this referendum will go?
I think we will definitely also see a slightly different approach if we compare it, for instance, with the online referendum that we saw at the beginning of the year. So I think surveys are also out. I mean, surveys, this is only one part of the reality, but I think we can expect also a certain participation. Simple things that people are, I think, thinking here is also like you mentioned a little bit like the hasty way in which the draft has been proposed. There are also other things, and I guess EC will elaborate on that. So people were also asking, like, how on Monday, 25th of July, like how does this physically work? Like the voting process, like where do I vote? What is exactly like the procedure for that? However, what I would also like to throw in a bit, and this is touching your question, the whole consultation process has, of course, also included like another additional dimension, which is the socio-economic dimension. Yeah, and Tunisia is facing this main challenge for several years, but especially also after and during the pandemic crisis, now with the war in Ukraine, like an intense challenge, and the need for deep reforms of the economic, of the financial sector, also a package and a deal that is necessary, or that is desired with the IMF. My question is a little bit like in this whole constitutional, or this whole consultation debate, the constitutional issue, the question of democracy, the working out of a constitutional draft has a little bit sidelined these relevant questions. We know exactly, I mean, the constitutional dimension is only one dimension when it comes to this mission or this task of kickstarting real reforms on the economic and financial and social side. Also, another dimension is, for instance, the present or the traditional setup of the economic sector in Tunisia. This is something that is a little bit immune, I think, to any legislation. We have this a little bit also like this tension or this issue of the involvement of the private sector. Then we have the social dimension, like with the traditional actors that get involved when it comes to a solution for how to deal, how to renovate, also how to rebuild the public sector. My question to you is also, how in all of this, in the constitutional debate, is this socio-economic mission that has also been like a part of the national consultation, how is this being included? And do you see, for instance, when we talked about the legislation of the presidential powers according to the new draft, would that even be something like a way into the right direction when we see, I'm provoking here a little bit, when we see that people in Tunisia have very often also criticized not the 2014 constitution, but a little bit like the reality that we faced until last summer in the parliament, parliamentarism itself. That means like in situations where quick and tough decisions need to be done during a pandemic, in the discourse on the economic reforms, that there has been a paralysis also. If you now see a little bit, like think about the new constitutional setup, is this something that takes into account this huge socio-economic task that the present government and regime and also any future government of Tunisia has to tackle?
Professor Klebe?
Thank you. So maybe there was a lack in what I presented about the constituent process, is what Mr. Malte talked about, the public consultation that has been presented by the president, that as the ground on which he will prepare his draft. But what is surprising now in the draft he published is that the part of the draft written by the Commission Belaid has been removed, because in the I think you have already read the Belaid draft. There is a very important part concerning the social and economic rights and the social and economic model of society that will be set up with the new constitution. This part has been removed from the draft published by the president, and it is surprising because in his national consultation, there is an important part related to economic expectations of people, about economic model expected by people. And so all these have been removed, and the draft emphasized on identity matter and on the institutional engineering, and this is quite surprising. Now, what about the crisis we are facing? Tunisia, I think, is facing a very deep crisis, economic crisis, and we listen very little from the president about this crisis and about what he proposed to take out of this. There is very little communication, and I think there is very little solutions. He has very little, maybe not solutions at all, and that's why I think he's focusing on the political matter, on the constitutional matter, because and the interest of all people, the public debate, all focused on this question of constitutional matter, and forgot all the most important thing, the everyday life of every one of us. It is a question of everyday life. The economic problems are daily problems for every one of us today. and the attention has been removed from this vital realm to something that is not really urgent. There is no emergency to make a new constitution. There is no need to make a new constitution. That's what the president didn't want to hear too. Many jurists, many lawyers said we don't need a new constitution. This is not. We don't need a new constitution, and the most important thing, we can't make a new constitution under crisis powers, under a situation of exception. We can't do that neither ethically, neither politically, neither legally. It's not legal. Any state of exception is not, when we are in state of exception, we cannot change the political system. It is a coup. When you do such a thing, it is a coup. So we don't need it. It's not the adequate the adequate time to do that. Today, the most urgent thing is the economic matter. So this makes a problem. And to go back to the national consultation, the president says things he doesn't respect. He said that he will consult people to make a draft of constitution, to change the constitution. He didn't even he didn't even respect the results of the national consultation. 2/3 of the people who participated, I think maybe you already know that the amount of the participators was very little.
7.5%.
Yes, it is about 5%, but within these 5%, 2/3 said they don't need a new constitution. They just need maybe some amendment to the 2014 one. Just 1/3 called for new constitution. So he followed the third part and neglected the 2/3 one. This is first. Second, about the political matter, he took apart the political field and focused on the economic, field, and focused on the political choices, on a new system, totally new system. This strange bottom-up. I call it the bottom-up because I don't know another qualification of what he's calling to set up. So even the promises he doesn't keep them. He doesn't keep them, and this is really worrying about what will come up after the referendum. Nothing prevent from a new amendment or a new draft or a new constitution or a new process. He made a precedent. With what he did, he made a precedent for him and for anyone will follow him. So we are within a system without any legal boundaries, because now, so this is very worrying about. If we have no more legal boundaries, so you can do tomorrow, you can do everything you want, you or anyone who will follow. So this is, I think, the most worrying thing in his process. Even his promises, he doesn't respect them.
Looking at the time, I'd like to end with one kind of final question, but something I'd like to point out, because I think it's sort of the quintessence looking back, but also looking forward. I think no matter the power system, so if we look at a presidential system or a democratic system, if it does not go hand in hand with economic stability and prosperity, it is bound to fail. And I think what we've seen in the last 10 years is that also the economic situation has not benefited Tunisians enough in order to be fans of the 2014 constitution and in fact to be supportive of the president and his actions now. And I think also looking ahead, a lot will matter, as Maite pointed out, on the economic situation. I'd like to end and would also kind of like to ask you for final remarks with the question, how do you think this will continue? How do you see Tunisia following up after the referendum? What do you think will happen? And at the same time, do you expect a sort of, let me call it resistance? This doesn't only mean on the street in form of demonstrations, but do you also expect now a much bigger coordination between oppositional groups, civil society actors, women's groups, perhaps, that have always played a very big role in Tunisia? Do you expect a resistance now, and how do you think this will continue? And any final remarks you may have. Professor Klibi, perhaps we'll start with you, and then Said, feel free to cling on immediately afterwards. And then Maite, of course, as well.
Okay, you asked first about the what is the opinion in the society within the jurist group, but also within ordinary, let's say, ordinary people. There is now a large support to the president, but the problem is that this support is to the president, not to the draft, not to the constituent process. People doesn't matter about the referendum, about the constitution, the draft constitution, but about all that. People says he's a good guy, we are supporting him. Now, what will happen? I think, and I hope I'm wrong, really. Huh? What I think about what will happen after the referendum. As we are facing a very sharp economic crisis, I think comment dire, we had an accord with the
treaty
FMI,
an
yes,
agreement.
An agreement with the FMI, and this agreement will be implemented after 25 July. This means that the measures that has been demanded from the FMI will be implemented after the referendum, and everybody knows what are the consequences, the economic consequences of such an agreement. So I think when people will face these measures, I think they will wake up and they will understand that it's not a matter to support a person, it's a matter to support a project and to support at least a person that has a project and that has a project for immediate needs and immediate problems. So I think things will change after 25 July. And I think there will be a resistance. There is a resistance that is being prepared from now. I told you there has been a large meeting yesterday of the civil society that is preparing a strategy to face the referendum and its consequences. I think there will be a resistance. And when I said I hope I'm wrong, I mean I hope this resistance will be pacific, and it's not. I hope it will not turn to chaos after 25 July. And another thing also that people for which people don't make importance, that it's that the new constitution, if if the referendum makes this draft a new constitution, its implementation will take too much time, but because there are many new institutions that needs time to be set up. So I think for all this transitional period, the president will continue to have all powers in his hand. And the other problem, the other point that is missing in the draft, and unfortunately, very few people pay attention to this, is that in the transitory articles, there is no mention, absolutely no mention about crisis powers, about state of exception. No mention about when it will be, it will take end, when president will announce to Tunisians that we are no more under a crisis power system and we are under a normal political and civil life, and this is really worrying because we can interpret that as maybe continuing to live under this system endlessly. Nobody knows when it will stop. And there is no mention from the president about that. No one mentioned.
Another interesting aspect I find is that the final article says this constitution becomes effective from the date of the announcement of the final results. And the way that is stated, literally makes it sound as though, you know, the result itself doesn't matter, but the moment it's announced, this is what. Saied, please.
Yeah, and I think it's worrying because, again, when you compare the version that was submitted about this article to the one that was developed by the Belaid committee, you see also that was changed, because the Belaid draft was that the constitution will enter into force if the votes, if the yes vote actually gets a majority, and that was changed, removed to the version that makes it actually look that the results of the referendum will not matter and that the constitution will enter into force anyway. And that's also one of the reasons why people are boycotting, because they believe that their votes or their decision doesn't matter. And anyway, it didn't matter before in the process of developing this constitution, and it won't matter in the process of adopting it. So just some few remarks about what has been said, and also to conclude. One is about this argument of the popularity of the president. And again, I think, you know, this is something that's been repeated several times, never been tested, or when it was tested during the electoral, during the istishara or the electronic consultation, and the electronic consultation was not a success, at least in terms of participation. We are talking about 6%, 7% of registered voters who participated in that process. So if the president is popular, you would feel that such popularity is going to be reflected by a movement that would support his initiatives, and that didn't happen so far. Let's see what's going to happen during the referendum. What's the percentage of people who are going to be participating? To highlight here also that there is no quorum, no threshold for the referendum or for the constitution to be adopted. So even if few thousand or tens of thousands participate and vote for it, then it would enter into force. It's legally or formally accepted. Or substantively, I don't think that would add any legitimacy to the process. And the president can continue, of course, using his state of exception power, ruling unchallenged and unaccountable to anybody. But at some point, as Professor Salsabil was mentioning, there are institutions that need to be put in place. And gives on the right of people to directly elect people, you would still need the participation of political parties. You would still need the involvement of the people. The president believes that he can do it all by himself and only him can fix things. I don't think that will result in any kind of stability midterm, long term. And I think moving forward, one important element that needs to be highlighted and that needs to be just highlighted in terms of also comparative experiences, because we were discussing about democracy did not deliver for the Tunisian people at the economic level. And when you compare to other transitional processes in East Europe, even in West Europe at the time with Portugal and with Spain, there was always an investment and a commitment from the international community, or at least in this specific case from the European Union, to ensure that political democracy or liberal democracy goes hand to hand with the kind of economic growth and economic stability that can make the system working for everyone. And that's never happened in Tunisia, and that's one of the biggest failures of the international community in terms of supporting the Tunisian democracy and ensuring that, in addition to the kind of liberal democracy and public freedoms and all the gains of the past decades in terms of independent media, independent civil society, civil and peaceful transfer of powers, free elections, independent electoral commission, etc. All those gains were not supported at the economic level to the points that people can see the difference. And I think the international community can still play a role. And it's important for the international community just to not give up to the authoritarianism that is being put in place in Tunisia right now, and to ensure and to request and ensure a return to the constitutional order, a return to separation of power, a return to judicial independence, and reestablishment or the reinstatement of the constitutional bodies that were dissolved one by one, and all the gains that were dismantled one by one by a president that rules for himself, by himself, and without any meaningful involvement of political parties, civil society, or other relevant stakeholders. And that support from the international community, if it's there, if there is a political will to push for it, will be matched by a response from civil society and from the Tunisian people when they realize, and I think it's important here to highlight, that at the economic level, that the situation is just deteriorating by the month, by the day, and that this is unsustainable in the long term.
Absolutely. So I completely agree with that. And if we had a lot more time, I would now maybe ask you about the statement of the EU High Commissioner of, just recently. And there's so much other things we could talk about. Malte, allow me to kind of thank both of you from CAS and to sum it up with that. I think this was extremely interesting. 45 minutes aren't close to enough. We've realized. Thank you for taking even more time and sharing your insight and your expertise. We will have to see how it goes, as you say, and I mean, I hope for the very best for Tunisia. And thank you for taking the time. We'll stay in touch. I hope to see you all soon. And
thank you. Thanks so much.
Yeah, thank you for this.
Thanks so much. Thank you.